Good morning, ladies and gentlemen. Welcome to the September 25, 2024 meeting of the Board of Oil, Gas, and Mining from our remote location here today in Vernal, Utah. We're very glad to be here. Feel very welcome. We're going to move right into our meeting so that we don't interfere with the beginning of the Uintah Energy Summit. And we're going to start with Director Thomas doing a quick update here. Miss.
Thanks, Chairman. I appreciate it. And again, we'll try to be brief in light of time. Just a few things I'd like to cover today. First, the proposed board hearing schedule for 2025. I would like for the board to first understand that in September, you're going to have the opportunity this month to review it. And then next month, if all is approved, I'll bring it back for ratification. So we have that understanding. Most of the board meetings will continue to be held on a Wednesday, except for a few exceptions that are outlined in your material. We normally combine the November-December board hearing to allow for holidays and travel. A notable exception this year, or pardon me, in 2025, the July hearing date was moved to the 5th Wednesday to accommodate a conflict with Pioneer Day holiday, which occurs the day after the 4th Wednesday of July in 2025. So that is before you now, and you're welcome to review that, and we'll ratify it next month. Everybody here? Okay. Item number 2, other, is actually pretty thin. I do appreciate everyone coming this year to do this. I first personally want to congratulate Council Gary Wright on the birth of his first granddaughter. And again, for those of you who know, he is not incredibly youthful. He just looks that way because of healthy, good living. We're almost the same age. I'm joking, not really. But congratulations on him. I understand his granddaughter was born Friday. Is there any details you want to provide, Gary?
She was born Sunday morning early, and she's adorable.
Thank you.
Congratulations, Gary.
Thank you, everyone.
And yes, he is biased, but I have seen pictures, and she is definitely a cute little kid. So thank you for that. I also want to give a shout out to our staff. This is all going so far seamless this morning with dual locations. Our AV person, a team led by Matt Morgan, has, I don't know what he's done to enable all of this, but it's really great. And especially we have a lot of administrative staff who have provided some excellent service coordinating all of this. My administrative assistant, Patty Rowe, obviously the, Julianne Rogers, who you're familiar with, they have put in long hours and done a lot of work to pull this together. So for the record and off record, we really appreciate their effort and assistance this morning in getting this all together. The last item, or item number 3 that I want to talk about, is the next month's agenda and division calendar. Next month's meeting will be on Wednesday, October 23rd. And we actually have a relatively heavy schedule, 16 dockets to discuss. A number of those, I think, are going to be covered by hearing examiners. But come prepared. It could be a very full day. And hopefully, as we work through board processes, we can make sure that the board's time is best utilized moving forward. And that's all I have. Members of the board, if you have any questions, I'm happy to speak to them.
Board, do you have any questions? You know, I'd also like to thank the staff here in Vernal for allowing us to use the space and for getting it all set up for us. It's great space, great venue, and we really appreciate what you do for us. We have a new organization, I guess. We no longer have to break between the informal session and the formal session like we used to. It is now seamless. Excuse me. So we are going to move. Oh, Council just reminded me, do we have any public comment? Seeing none. We're going to move right into the formal session. We have some board members who are virtual in Salt Lake City and the four of us here in Vernal. So if we can commence with docket item number 1. Docket number 2024-047, cause number 132-49. In the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the 9 Stanley series of wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations in all sections 13 and 14, 3 South, 4 West, USM, Duchesne County. Do we have our hearing examiner here? Oh, Mr.
I'm here in Salt Lake City.
Mr. Baza, are you ready to commence?
Yes.
Okay. Do we have a division? Who's representing?
Yeah, Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
And Mitch Mayo of Lear & Lear PLC. I'm actually filling in for co-counsel Fred McDonald, who is unavailable to attend here today.
Thank you.
And Gary White, I am counsel for Mr. Baza, the hearing examiner.
Thank you. Mr. Baza, would you like to commence?
Yes, there's a strange audio delay here, so you'll have to bear with me so that I don't confuse myself in this matter. This is going to be a bit redundant because I was hearing examiner for 3 matters, so you'll probably hear the same dialogue from me for the first 3 items. But in this matter, I was John Baza. I was designated by the board to be a hearing examiner in this matter. The proceeding was conducted on Wednesday, September 18th of 2024. The proceeding was held with an anchor position at the Department of Natural Resources building in Salt Lake City, Utah. No member of the public nor any party opposed the request for agency action by OVINTIV. During the proceeding, various sworn declarations and exhibits were admitted into evidence. Additionally, the testimony from expert witnesses was received. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on behalf of OVINTIV. After reviewing the request for agency action, the sworn declarations, and admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommend the following. OVINTIV provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceedings was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified, given the economic and geological conditions presented in connection with the drilling of these wells. I therefore recommend that the 300% non-consent penalty be imposed as requested, and OVINTIV met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. Counsel for OVINTIV, Mr. Fred McDonald, prepared proposed findings of fact, conclusions of law, and an order granting the request for agency action. Both the division and I reviewed, and after some minimal edits, approved the proposed order. I then executed the proposed order and filed it with the board's legal assistant this morning. It should now be ready for the board's review and execution. and I'm prepared to answer any questions. And if I've screwed anything up, Gary White will have to correct my errors.
I didn't detect any errors.
Mr. Haynes, do you have any comments?
No substantive comments. Yeah, the division participated in the hearings, and the division after the testimony and the evidence presented is in support of this request as well.
Thank you. Mr. Mayo?
No comments other than to individually thank the board and division staff separate from this matter. These last couple months have been really intense, and board and division staff have done everything they can to try and rise to the occasion and help make sure these matters get through. And today's hearing is an example of that. So for this specific matter, no comments. Everything's as stated in the order.
Thank you. Board, do you have any questions or comments?
A question. Quite often at the end of the average weighted royalty schedule, there is a lease by Ovintiv. I see it's for 12.5 acres on the Stanley Wells. What is that? Sounds like a lease to yourself.
Yeah, I mean, unless I'm incorrect, that's the lease under the JOA. Is that correct? And I've got Uintah witnesses here. They're not sworn in, but I'm happy to have them answer. The short answer is that's their unleased minerals they own in the unit, and they're subject to the lease that's attached to the JOA they execute to govern kind of their own costs for their unleased mineral portion, because the Ovintiv operator is different than Ovintiv mineral owner, so they have to charge Ovintiv mineral owner costs under that same JOA they ask.
So you own those minerals, and it is a lease to yourself. Yeah. Okay.
If we were to ever go non-consent in a future operation, that's why
Okay. Okay.
Do we have any other questions from board members? Before we vote, I'd like to say all board members are present except for Al Walker, who is absent from the meeting. We have two board members, Steve Church and Rich Warden, who are remote in Salt Lake City. Do I have a motion to accept?
I would move that we accept this request.
Second? I second. It's been moved and seconded. All in favor, please say aye.
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 It's unanimous. Please prepare the order here. Okay. Motion has carried, and we are going to move on to docket item number 2. Mr. Mayo, are you doing this one also?
Unfortunately, I'll be sitting here for a bit, so I'm sorry.
Well, we like to keep you busy as long as you're here, right?
I'm happy to.
Docket number 2, 2024-048, cause number 132-50. In the matter of the request for agency action of OVINTIV USA INC for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Evelyn 4-4, 3-1-4-9-7H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of all sections 4 and 9, 3 South, 1 West, USM, Duchesne County. And we have appearance of counsel, Mr. Mayo.
Again, Mitch Mayo of Lear & Lear PLC on behalf of petitioner OVINTIV USA Inc. To be clear for the record, I'm filling in for Fred McDonald, who participated at the hearing examiner hearing.
Thank you. Division.
Yeah, Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
An examiner.
Gary White on behalf of John Baza, who acted as the hearing examiner here.
Thank you. Mr. Baza.
Thank you, members of the board. Thank you, members of the board. As read by the board chairman, this matter is also for OVINTIV, and this is John Baza. I was again designated as the hearing examiner by the board in this proceeding. The hearing examiner proceeding was conducted in this matter on Wednesday, September 18th, 2024. Proceeding was held with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. No member of the public nor any party opposed the request to agency action. During the proceeding, various sworn declarations and exhibits were admitted into evidence. Additionally, the testimony from expert witnesses was received. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on behalf of OVINTIV. After reviewing the request for agency action, the sworn declarations and admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommend the following. OVINTIV provided sufficient and adequate notice of opportunity to the parties it was asking to compulsory pool. Proper notice for this hearing, examiner proceeding was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geologic conditions present in connection with the drilling of these wells. I therefore recommend that the 300% non-consent penalty be imposed as requested, and OVINTIV has met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. Counsel for OVINTIV presented proposed findings of fact, conclusions of law, and the order granting the request for agency action. Both the division and I reviewed, and after some minimal edits, approved the proposed order. I then executed the proposed order, or the hearing examiner's recommendations, I should say, and then filed it with the board's legal assistant this morning. It should now be ready for the board's review and execution, and I am again prepared to answer any questions the board may have about the proceeding.
Thank you, Mr. Baza. Division.
Yeah, the division has no additional comments to add to Mr. Baza's. We've also reviewed the proposed order and in agreement to what was submitted. Thank you.
Mr. Mayo.
Same, no comments to add to this one.
Board, do you have questions? Salt Lake, do you have any questions? Seeing none. Do I have a motion?
I move that we approve the request for agency action as recommended by our hearing officer.
I'll second.
Thank you. It's been moved and seconded. All in favor?
Aye.
Aye.
Any opposed? Thank you. It's been unanimously approved, and we will get the order out. We're trying to fix this little delay we have that's making it kind of difficult to hear, but I don't know if
Mic check 1, 2. Salt Lake, can you hear us?
Yes, Vernal, we're picking you up. Picking you up.
Are you still getting a delay back there?
I believe we still are.
I think we still are.
Mr. Baza, can I have you give us a mic check as well?
Testing, testing, 1, 2, 3.
Testing, 1, 2, 3.
Thank you. That does sound better on our end.
Salt Lake, can you please give us a mic check again?
Testing, testing, 1, 2, 3.
Testing, 1, 2, 3.
Okay, checking mic again.
Okay,
1, 2,
checking
3.
mic again. 2, 3.
Mic check. Salt Lake, can you give us another mic check, please?
Again, mic check. 1, 2, 3. I didn't hear any. Yeah. Mic check, 1, 2, 3.
Salt Lake City, we are ready to begin. If you could give us a countdown.
We're live in 5, 4, 3.
Vernal,
2,
we are going
1.
live. Vernal, if we can have the room quiet.
We're ready to.
Vernal boardroom,
start
let's
up the
quiet
meeting
down so we
again.
can start. Thank you. Sorry, Carmen, can you give us a countdown now?
We're live for our briefing board meeting in 5, 4, 3, 2, 1.
We're ready to reconvene the meeting here in Vernal. We're going to move on to docket item number 3. Docket number 2024-051, cause number 132-53. In the matter of the request for agency action of OVINTIV USA INC for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Sandra, Utah 16-7, 4-2-17-29-7HX well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations in all of section 17, 20, 29, Township 4 South, 2 West, USM, Duchesne County. Appearance of counsel, Mr. Mayo.
Thank you, Madam Chair. Mitch Mayo of Lear & Lear PLLC, appearing today on behalf of OVINTIV USA Inc., the petitioner. For the record, I was not the attorney of record at the hearing examiner hearing, but I'm covering for Mr. McDonald here today.
Thank you. Ms. Haynes.
Yeah, Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Gary White for John Baza, the hearing examiner.
Mr. Baza.
Thank you, Madam Chair. And again, this is John Baza. I was the appointed hearing examiner by the board for this proceeding. Hold on just a second. I think we're still getting some feedback, but I'll go ahead and proceed. This was the final matter that I was appointed as the board's hearing examiner, so blessedly it's the last time you'll have to hear from me this morning. Hearing examiner proceeding was conducted in this matter on Wednesday, September 18th, 2024. The proceeding was held with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. No member of the public nor any party opposed the request for agency action. During the proceeding, various sworn declarations and exhibits were admitted into evidence. Additionally, the testimony from expert witnesses was received. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on behalf of OVINTIV. After reviewing the request for agency action, the sworn declarations, and admitted exhibits, and hearing the testimony presented at the hearing, I found and recommend the following. OVINTIV provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geologic conditions present in connection with the drilling of these wells. I therefore recommend that the 300% non-consent penalty be approved as requested. And finally, OVINTIV met its burden of proof and otherwise satisfied all legal requirements for compulsory pooling the non-consenting parties. Counsel for OVINTIV prepared proposed findings of fact, conclusions of law, and a proposed order granting the request for agency action. Both the division and I reviewed, and after some minimal edits, approved the proposed order. I have executed the proposed order and filed it with the board's legal assistant this morning, and it should be ready for the board's review and execution at this point, and I'm prepared to answer any questions. Also, I might say that since this is the last matter I was hearing examiner for, I truly appreciate the help from all of the division's staff and especially Julianne Carter and the technical staff for being able to conduct these matters electronically. I found it very easy and convenient for the parties, and I just wanted to thank them personally for all of the help that they gave in these matters.
Thank you, Mr. Baza. Division,
Yeah, no additional comments for the division.
Mr. Mayo.
I only have one thing to note. At the hearing examiner hearing, OVINTIV submits a Exhibit 8 in this cause. It's the working interest summary. It clarifies the percent of interest being pooled, essentially. At the hearing examiner hearing, there was a correction to that based on changes during the process, people who'd leased or participated, and that was revised and accepted by the hearing examiner. However, since then, OVINTIV realized another kind of math mistake and has submitted a third revised Exhibit 8. I don't think technically it's been admitted into evidence. I'm not sure it's terribly important, but I thought I'd alert the board if they'd like to admit that into evidence.
Do you have the changes?
I don't, but they have been, I don't have them with me.
Okay,
They
okay.
have been filed of record. And so the third revised Exhibit 8 would be.
Is the board okay with revised third? Okay, we'll take it.
Thank you. No further comments from OVINTIV.
Board, do you have questions or comments? Salt Lake, do you have any questions? Mr. Moon?
So my family has a pretty significant interest in this well, so I'll just recuse from voting on this one.
Thank
It's all
you.
leased, but
Thank you.
lots of moon wells on this one, so.
Thank you for letting us know. Appreciate that.
Do we have any other, Mr. Galecki?
No, I don't have any.
Seeing no other comments, do I have a motion?
I'll make a motion that we approve the request for agency action as presented by Mr. Baza.
A second.
All in favor, please say aye.
Aye.
Any opposed? Motion carries. Mr. Moon has abstained, and we'll go ahead and sign the order. Maybe. All right. Mr. Mayor, are you up again?
I am.
You're on the
Madam
hot
Chair.
seat today.
I'm here for a while.
We're moving on to docket number 4. This is docket number 2024-052, cause number 132-54, in the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Fitzgerald, Utah 9-35, 4-2-2-11-1H well, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of all sections 2 and 11, 4 South, 2 West, USM, Duchesne County, Utah. Appearance of counsel.
Mitch Mayo of Lear & Lear PLLC on behalf of petitioner OVINTIV USA Inc.
Mr. Haynes.
Yeah, Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Gary White for John Rogers, the hearing examiner.
Mr. Rogers.
Okay. Good morning,
proceed.
Chairman Garrison and members of the board. My name is John Rogers, and I'm an environmental manager at the Division of Oil, Gas, and Mining. I acted as a hearing examiner in this proceeding as directed by this board. A hearing examiner's proceeding was conducted in this matter on Wednesday, September 18th, as described by Chairman Garrison. The proceeding was held as an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. No member of the public participated in that hearing. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence from Mr. David Dale, manager, Rockies Land, and Mr. Christopher Wall, reservoir engineer advisor, both from OVINTIV. These declarations were reviewed by me prior to the hearing, and Mr. Mitch Mayo was present at the hearing and acted as counsel for Ovintiv. Both of the Ovintiv witnesses were accepted by me and the division as expert witnesses in their field for this matter. They also presented live testimony electronically in the hearing. On September 10th, 2024, the division filed a notice of non-response to Ovintiv's request for agency action, expressing non-opposition to the granting of the request. At the conclusion of the hearing, Mr. Andrew Hayes, on behalf of the division, stated support for the request for agency action. No other party filed a response to the request for agency action or appeared or participated at the hearing. As a consequence of their failure to timely reply or give a response and appear at the hearing after the notice, the Division of Oil, Gas, and Mining had the opportunity to cross-examine the witnesses presented on the behalf of Ovintiv. After reviewing the request for agency action, the sworn declarations, and admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommended the following. Ovintiv provided sufficient and adequate notice for opportunity for the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceedings was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified, given the economic and geologic conditions present in the connection with the drilling of these wells. I therefore recommend that the 300% non-consent penalty be imposed as requested. Ovintiv has met its burden of proof and otherwise satisfied all legal requirements to compulsively pull the non-consenting party. For your interest, the working interest owners are Ovintiv at 92.3% approximately, and a non-op working interest of the JOA about 7.5%. The compulsively pulled interest is 0.17%. The average rated the average weighted fee landowner royalty interest is 18.5. Ovintiv's counsel, Mr. Mitch Mayo, prepared proposed findings of fact, conclusions of law, and order granting its request for agency action. Both the division and I reviewed and approved the proposed order. I executed the proposed order and filed it with the board's legal secretary. I should now be ready for the board's review and execution. I'll take questions if you have any at this time.
Mr. Haynes.
No additional comment from the division.
Mr. Mayo.
None. Available to answer questions. I was counsel at the hearing examiner hearing, but no comment.
Board, do you have any questions? Salt Lake, do you have any questions? Hearing none, do I have a motion?
I move that we approve the request for agency action.
Second.
I'll second.
It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Any opposed? Sorry, I jumped the gun with Salt Lake here. The matter has been approved. We will go ahead and sign the order. All right, that concludes item number 4. We'll move on to item number 5. Docket number 2024-049, cause number 132-51. In the matter of the request for agency action of XCL Resources, LLC, on behalf of XCL Asset Co. and Asset Co. LLC for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,280-acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Colton formations, comprised of sections 28 and 33, 2 South, 2 West, USM, Duchesne County. Mr. Mayo, appearance of counsel.
Thank you, Madam Chair. Mitch Mayo again, Lear & Lear PLLC on behalf of petitioner XCL Resources and XCL Asset Co. in this cause.
Thank you. Division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Gary White for the hearing examiner, John Rogers.
Mr. Rogers, would you please proceed?
Thank you, Chairman Garrison and members of the board. My name is John Rogers, and I'm Environmental Manager for the Division of Oil, Gas, and Mining. I acted as a hearing examiner in this proceeding as directed by this board. A hearing examiner's proceeding was conducted in the matter on Wednesday, September 18th, as described by Chairman Garrison. The proceeding was held in the Department of Natural Resource Building here in Salt Lake City, Utah. No member of the public participated in that hearing. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence from Mr. Kevin Annison, Vice President of Business and Development, and Mr. Mark Gravier, Vice President of Reservoir, both from XCL Resources. These declarations were reviewed by me prior to the hearing. Mr. Mitch Mail was president of the hearing, acted as counsel for XCL. Both of XCL's witnesses were accepted by me and the division as expert witnesses in their field of work for this matter. They also presented live testimony electronically in the hearing. On September 10th, 2024, the division filed a notice of non-response to XCL's request for agency action, expressing non-opposition to the granting of the request. At the conclusion of the hearing, Mr. Andrew Haynes, on behalf of the division, stated support for the request for agency action. No other party filed a response to the request or appeared or participated in the hearing as a consequence of their failure to timely reply or give a response and appear at the hearing after the proper notice. The Division of Oil, Gas, and Mining had the opportunity to cross-examine the witnesses presented on behalf of XCL Resources. After reviewing the request for agency action, the sworn declarations and admitted evidence and exhibits, and hearing the live testimony presented at the hearing, I found and recommended the following. XCL Resources provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pull. Proper notice for hearing examiner proceedings was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified, and given the economic conditions and geologic conditions present in connection with the drilling of these wells, I therefore recommend the 300% non-consent penalty be imposed as requested. XCL Resources has met its burden of proof and otherwise satisfied all legal requirements to compulsory pull the non-consenting parties. For your interest, the working interest percentages are XCL Resources approximately 99.99%, compulsory pulled interest 0.007%. The average weighted fee landowner royalty interest is 17.285 approximately. XCL's counsel, Mr. Mitch Mail, prepared proposed findings of fact, conclusions of law, and an order granting its request for agency action. Both the division and I reviewed and approved the order. I executed the proposed order and filed it with the board's legal assistant. It should now be ready for the board's review and execution. I'll take any questions you may have on this matter at this time.
Division.
Yeah, no additional comment by the division.
Mr. Mayo.
No comment from XCL.
Board, do you have questions or comments? Salt Lake, do you have questions or comments? Seeing none, can I have a motion, please?
I'll make the motion that we approve the request for agency action as presented.
I second.
It's been moved and seconded. All in favor, please say aye.
Aye.
It has been unanimously approved. We will go ahead and execute that order. We are now moving on to item number 6. Docket number 2024-050, cause number 132-52. In the matter of the request for agency action of XCL Resources, LLC, on behalf of XCL Asset Co. Asset Co. LLC, for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 2,560-acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Colton formations, comprised of sections 27, 28, 33, and 34, 2 South, 2 West, USM. Appearance of counsel, Mr. Mayo.
Thank you, Madam Chair. The last time you'll hear from me today, Mitch Mayo of Lear and Lair PLLC on behalf of the petitioner, XCL Resources and XCL Asset Co.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Gary White on behalf of the hearing examiner, John Rogers.
Mr. Rogers, please proceed.
Okay, thank you, Chairman Garrison and members of the board. Once again, my name is John Rogers, and I'm an environmental manager for the Division of Oil, Gas, and Mining. I acted as a hearing examiner in this proceeding as directed by this board. A hearing examiner proceeding was conducted on Wednesday, September 18th, for the matter as described by Chairman Garrison. The proceeding was held in the anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. No member of the public participated in this hearing. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence from Mr. Kevin Annison, Vice President of Business and Development, and Mr. Mark Grave, Vice President of Reservoir, both of XCL Resources. These declarations were reviewed by me prior to the hearing, and Mr. Mitch Mayo was present at the hearing and acted as counsel for XCL. Both XCL's witnesses were accepted by me and the division as expert witnesses in their field of work for this matter. They also presented live testimony electronically in the hearing. On September 10th, 2024, the division filed a notice of non-response to XCL's request for agency action, expressing non-opposition to the granting of the request. At the conclusion of the hearing, Mr. Andrew Haynes, on behalf of the division, stated support for the request. No other party filed a response to the request for agency action or appeared to participate in the hearing as a consequence of their failure to timely reply or give a response and appear after the proper notice. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on behalf of XCL Resources. After reviewing the request for agency action, the sworn declarations and admitted exhibits, and hearing the live testimony presenting at the hearing, I found and recommend the following. XCL Resources provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pull. Proper notice for hearing examiner proceeding was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable and should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified, given the economic and geologic conditions. XCL Resources has met its burden of proof and otherwise satisfied all legal requirements to compulsory pull the non-consenting parties. For your interest in this matter, the working interest owners approximately are XCL Asset Company, 99.99%, compulsory pulled interest, 0.0035%. Average rated fee landowner royalty interest, 6.5%. XCL's counsel, Mr. Mayo, prepared proposed findings of fact, conclusions of law, and an order granting its request for agency action. Both the division and I reviewed and approved the order. I then executed the proper order and filed it with the board's legal assistant. It should now be ready for your review and execution. If you have any questions, I'd take them at this time.
Division.
No additional comment.
Mr. Mayo, any comments?
None from me. Thank you.
Board, do you have questions or comments? Salt Lake, do you have questions or comments? Hearing none, could I have a motion?
I move we approve the request for agency action.
Second.
It's been moved and seconded. All in favor, please say aye.
Aye.
It has been unanimously approved. We will go ahead and execute that order. Thank you, Mr. Mayo.
Chairman Garrison?
Yes.
Can I just add, I want to reiterate what Mr. Baza said. I appreciate the support of the staff, the legal, and the AV group to get this process going. They are running very smoothly, and also thank the petitioners for their involvement and having their witnesses available electronically.
Thank you. Appreciate it. We're going to move on to our last and final matter of today. Thank you, Mr. Mayo. We're going to take a short break here while council gets set up for the next hearing. This is docket number 2024-053, cause number 130-35, in the matter of the request for agency action of Berry Petroleum Company, LLC, for an order 1, partially vacating and amending the board's order in docket number 2012-020, cause number 139-92, and 2, establishing an approximate 1920 laydown overlapping drilling unit for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of sections 32 through 34, 4 South, 5 West, USM, Duchesne County. We have appearance of counsel.
Brent Chickens, Pilgrim Johnson, PLLC, on behalf of Berry Petroleum Corporation.
Thank you. Mr. Haynes?
Yeah, Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining. And I'd like to also just have the division staff with me just introduce themselves at this time, if that's okay.
Thank you.
Hi, my name is Megan Crocker, and I'm the Engineering Geoscience Manager.
Regina Acko, Petroleum Engineer.
Thank you. Mr. Chicken?
So recognizing that we have some timing constraints today, I'm going to try and be as concise as I can. This is actually a really simple request. The only order involving these lands is Order 13992. It is a 12-year-old order. It created a single 1280 for a single well. That well was never drilled. The only other thing this order did was amend the board's general siting rules to allow vertical wells to be drilled within 660 feet of that single never drilled horizontal well, rather than under the rule, which is 920 feet. We did receive, as the board's aware, the division filed a response, but we have also worked with the division since receiving that response, because there's a couple of small issues. One of them was the nature of our request. Did we want to just partially vacate 13992, or did we want to fully vacate it because it didn't really have much else to it once the spacing unit was gone? Berry Petroleum didn't have a preference. After speaking with Mr. Haynes, we've decided to orally amend to fully vacate Order 13992. So that would be the only change that we would be making from the RAA as filed, is instead of partially vacating, we're just going to get rid of it and create a new order. And as far as the new order, what we're asking for today, it is vacate the existing 1280 and create a new 1920 acre spacing, laydown spacing unit, overlapping scheme, which is, as you'll see from our exhibits, it's exactly the same scheme that is in the adjoining orders 130, 13930 and 13920 and 13932. So those are the recent orders done by WM operating in Berry in the last 12-ish months. So that's really all we're asking for here. And so we would vacate that 1280. We would be asking for a single 1920, 16 wells, in keeping with the 130-20, 130-32 orders. We would ask the board to take administrative notice of the land geology and engineering testimony, importantly, for those prior orders. The reason being that this is the same exact spacing scheme that those orders have, and so the support from the science side of things is perfectly equivalent. I will note that there were some questions in the response from the division. I believe that the nature of that was really more like, well, come to the hearing and convince us and we'll approve, we'll support your request, which we absolutely appreciate. And that gives us guidance, and we have worked with the division a bit to understand better what type of exhibit changes they wanted to see. On Friday, we filed an unopposed request to amend and supplement our exhibits. That was granted by the board this morning. Thank you very much, which makes the exhibit deck in front of you accurate and proper, which it would not have been without that order. So thank you very much for the order. I will leave any other issues in the response to the division's counsel to discuss. I will say one other thing to note, we do have 6 existing wells on these lands in these 3 governmental sections, but Berry operates all 6 of those wells on a lease basis and owns the majority in all of the lands that we're going to be talking about today. So there's really no other third parties involved. And because I told Mr. Kensky I would bring this up, we will also ensure that one of the reasons this 1920 is useful is so that we can have it established so that we can enter into communitization agreements. As you'll see, the lands involved in this RAA today are heavily tribal. You need to communitize those tribal lands through the BLM and the BIA. This will help us do that. And of course, as normal, our proposed order, assuming that the relief sought today is granted, will reflect the obligation to go and get a CA for these lands to further develop them. Our witnesses today are Seraphim Kupek, who is a landman for Berry, Kelly Bruchet, and Mr. Kupek is sitting to my right. Kelly Bruchet, the senior staff geologist for Berry, is sitting right over my right-hand shoulder, and Jacob Wright is the reservoir engineering manager for Berry, and he is sitting next to Mr. Bruchet. I will leave it up to the board whether you would like to do the swearing in dance now or individually with each witness.
I think we can swear them in all at once. Do we have a court reporter in Salt Lake who can do the swearing in?
Yes. Please raise your right hand. You solemnly swear that the testimony you shall give in this proceeding shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Thank you.
I would have nothing further for my introduction, but I don't know if there's any preliminary comments that the division or the board would like to make prior to getting into it.
No, we're ready for you to proceed with you.
Okay, great. I'm going to scroll down here. So here's our table of contents. It shows just a general outline of our exhibits. I won't spend a whole bunch of time on that. Here is our summary of what our request is today. This still says partial vacation because we only decided that this morning. It would now be vacation of Order 13992 in its entirety. That will vacate sections 31 and 32, Township 4 South, Range 5 West as a laydown 1280, and the establishment of sections 32, 33, and 34, 4 South, 5 West, as a laydown overlapping 1,920 acre DSU. This is, again, as we noted, essentially just an extension of the 13020 and 13032 existing spacing orders of the board. As my first witness, I will bring up the resume for Mr. Kupek. Mr. Kupek, if you could please state your full name, title, and employer for the record.
Thank you, Mr. Chicken. Good morning, members of the board. My name is Seraphim Kupek. I work for Berry Corporation, and I am a landman.
And have you testified before the Board of Oil, Gas, and Mining in Utah previously?
I have not.
Can you give just a very brief description of your educational and experience background for purposes of your testimony today?
I graduated from the University of Texas at Austin with a BBA in finance, a minor in accounting, and a certificate in energy management. I am also certified as a registered landman through the American Association of Professional Landmen, or AAPL. I also serve as the president of the Bakersfield Association of Professional Landmen, which is a local chapter of the AAPL. And I've been employed by Berry for 3 years. I work the San Joaquin Basin as well as the Uintah Basin, primarily the San Joaquin, but have recently been given additional responsibilities in the Uintah Basin and my work primarily revolves around acquisitions, leasing, and contract work.
Thank you, Mr. Kupek. With that, we will go right into your first exhibit. This is exhibit. Yes,
Could
yes,
we
ma'am.
just make sure there are no questions or comments about Mr. Coupe?
Sure.
Oh, so can I just clarify? Is Mr. Kupek just a fact witness?
He is just a fact witness for land purposes. Mr. Boucher and Mr. Wright, I will get them qualified. Mr. Boucher has testified as an expert before. Mr. Wright has not, but I'm sure you will be satisfied.
Okay, thank you.
Thank you.
So going to our first exhibit, which is Exhibit D, Mr. Kupek, can you please describe what is depicted on here in terms of the existing lands and the lands that we're looking to establish?
Absolutely. So this is a general overview of the subject lands. In blue, we have the existing DSU, which we are working to vacate. And in red, we have the proposed DSU, which we are working to establish. The blue is the 1280 and the red is the 1920. These lands are in sections from 31 to 34, Township 4 South, Range 5 West, USM, and the shaded red areas are established buried DSUs.
And as we'll see a little bit later, just to clarify, these shaded DSUs are currently regulated under orders 130, either 130-20 or 130-32, correct?
Correct.
And the relief you are seeking today, Barry is seeking, is substantially equivalent to the relief in those orders I just mentioned?
Correct.
There's no questions on this exhibit. We'll go to the next. This is Exhibit E, and this is showing the notification that we've done and Barry has done in connection with this RAA. Can you please describe what is depicted on Exhibit E, including the notice affected and the ownership categories that notice was affected to?
As Mr. Chicken mentioned, this is a map of the extent of the notification boundary that Barry provided notice to according to the rules and regulations for the notice period. We noticed all working interest owners and unleased mineral owners in sections 31 through 34 with an additional 40-acre buffer around sections 32 through 34. And within those sections, there was a mixture of tribal, fee, and state-owned lands and minerals.
Are there any board questions or division questions regarding Exhibit E?
Please proceed.
Thank you. I usually have a mouse. I'm not real good with this pad thing. Sorry, old school. Exhibit F. These are, we wanted to provide we've mentioned these orders several times. We did want to provide a graphical representation. So Mr. Kupek, if you could describe what is being depicted on Exhibit F.
Exhibit F shows offsetting orders within the area and shows that the DSU that we are proposing is a continuation of existing orders that we have in the area, following a similar scheme.
And again, just to confirm that the number of wells, the east-west or heel-toe setbacks, the north-south or lateral setbacks, the inner well setbacks that were approved in orders in cause numbers 130-20 and cause number 130-32 are equivalent and the same as being requested today with this RAA.
That is correct.
Thank you. Any questions on Exhibit F? Yes.
Might be early for this, but these are 3-mile horizontals. This whole area is spaced. What's your experience so far? Have you drilled some or in the plans? Or
I have personally never been a part of a 3-mile program.
Mm-hmm.
I I'm not sure if I can speak to the history of the company, but from what I know, no 3-mile horizontals were drilled before.
Okay.
I think our geology and engineering witnesses can speak a little bit more to that, because that's where their 3-milers are looking good right now so far. So we're trying to do that to maximize recovery. So, but please ask that question again, Mr. Moon. We will move to, well, before we move to Exhibit G, do you believe that the relief that is requested in today's RIA in cause number 13035 is going to protect correlative rights, minimize disturbance, avoid waste, and maximize resource recovery?
I do.
And were exhibits A through F prepared by you or under your direction, supervision, and control?
They were.
Other than a request to admit exhibits A to F to the record, either now or if you want me to wait till the end?
I think if we wait till the end and
No
do it one
problem.
time, thanks.
Then I have no further questions for Mr. Kupek, and unless the board or division has questions for him, I think he's finished.
Division?
Yeah, the division has some questions. Thank you. So in the request for agency action, and as you brought up, there's currently 2 existing vertical and 4 existing directional wells. I believe Mr. Kupek's probably the best one to speak to this. It was indicated that Barry is the operator of these wells. Are there other working interest owners in these wells other than Barry?
Correct. There are 6 wells within the DSU. As you mentioned, 2 vertical, 4 directional. Barry is the majority working interest owner at 75%, and Uintah Wax has the remaining working interest.
Okay, so Uintah Wax has the other 25%. Was Uintah Wax noticed of this
They were.
request? Okay. We just raised this issue just because, as will come up later, there is a request for 100-foot production interval setbacks. And we just want to make sure any party's correlative rights in those wells are protected.
Mm-hmm.
But we do have one other just comment. I'm not sure who addresses. I'll just bring it up now. When we're defining the formations in this request, there's 2 wells indicated that we're using to define the formations. The second well is the Shell Brotherson well. It contains a top depth, but not a bottom depth of that well. Just so, oh, it's the opposite way. It has the bottom depth and not the top depth. So if we could just clarify that when the order is put out.
Absolutely, and please ask that question again when we have an engineer or a geologist.
All right, thank you.
Neither Mr. Kupek nor I.
Okay. Okay, it's more a clerical thing, that is all.
And that's fine. The order will be, what it needs to be. But yes, let's go ahead and ask our other witnesses so that we can clarify that so that when I prepare it looks
Yes.
right.
And if I may clarify on those 6 wells, I mentioned that Barry has 75% working interest. There are some that Barry has 100% working interest. So
Okay.
it is a bit of a mixture, but Barry does have the majority working interest.
All right, thank you. No further questions.
Board, do you have any questions for this witness? Mr. Galecki?
I do, and maybe I'm just missing it, but on Exhibit F, it shows the cause that includes Section 31, but that's not part of it. Is that correct? Because it's for the 1920, it's Sections 32, 33, and 34.
It's included because that's the west half of the 1280 that's being vacated. So 31 is not going to be part of the new unit, but we couldn't. That's why. Let me scroll up here. This looks a little weird. I'm sure somebody looked at this notice boundary and was like, "Huh, why is that?" Well, we don't have to notice a 40-acre buffer around Section 31 because we're vacating it. You only have to notice that buffer when you are getting closer to people because of your requested setbacks. So it was kind of it is a little bit weird. Normally when you're vacating, the land that you're vacating is still inside of your new thing you want to do. In this case, we're leaving 31 out in the wind, and it just goes and becomes a unspaced 640 out in the world rather than, so that's why, but we didn't want to we needed to notice people in 31, and we needed to make sure that we were showing you the cause included all 4 sections, but only 3 of them are going to come out of it alive. I don't know how to put that.
Thank you for clarification. Any other questions? Okay, please proceed, Mr. Chicken.
Thank you very much. I would like to call my second witness, Mr. Kelly Bruchet. Mr. Bruchet, if you could please state your full name, title, and employer for the record.
Sir, my name is Kelly Bruchet. I'm a senior staff geologist with Berry Corporation out of Bakersfield. I've been there since November of 22.
And can you give us just a very brief exposition, as shown in your resume here, Exhibit G, of your educational and experience history in petroleum geology?
Yes, sir. I've got an undergrad from Western State College in Gunnison, Colorado. I've got a master's from Colorado School of Mines. I've worked Uintah Basin on and off for the last 10, 12 years now. Got some Permian experience, some other experience as well. So.
And have you appeared and provided testimony and evidence in causes before the Utah Board of Oil, Gas, and Mining in the past?
Yes, sir.
Based on Mr. Bruchet's education, experience, and prior testifying and providing evidence to this board as an expert in petroleum geology, I would like to ask that Mr. Bruchet's testimony and exhibits today be accepted as expert testimony in petroleum geology.
Division, do you have any?
Yeah, we have no objections.
Board? He's accepted.
Okay, thank you very much, Madam Chair. We will move right into Exhibit H, which is our type log for these lands, and a map that kind of connects those dots. Mr. Bruchet, if you could please describe what you are depicting on Exhibit H.
Yes, sir. This is a locator map and type log for the subject lands. The yellow star in the north is from the Barthelson well. It's the type log for the area. The blue box in the southwest portion of the map is the subject DSU, the one we are completely vacating. The red box is the subject DSU that we're going to establish. All the gray or dark gray lines and bold are Green River Wasatch horizontal wells. Again, like I stated, the yellow star is the type log. I would like to address Mr. Haynes' comment from earlier. On the right is the type log, and there shown is the proposed spacing interval. It should be the top of the TGR3 to the base of the Wasatch North Horn Formation. We can amend this if you'd like and specifically call that out a little clearer, but that is the interval that we are looking to space.
Sorry, just making a note.
No, you're good.
Do we have any questions from the board, the division or division staff on Exhibit H?
Division, do you have comments?
No, just as was mentioned, if you incorporate that, yeah, we're good with that.
Board, do you have any questions at this point? Please proceed, Mr. Chicken.
Thank you very much. It's kind of funny. I have a big enough mouth. I don't need that, but the machines need it. Moving on to Exhibit I. This is going to be a regional stress orientation map that's really going to show kind of the best ways to drill the horizontal wells so that they impact the subsurface formations at the correct angle to maximize recovery and avoid waste. Can you, Mr. Bruchet, please describe what you are depicting on Exhibit I?
Yes, sir. So like Brent said, this is a regional stress orientation map. The dark maroon lines that are dashed are the maximum stress orientation, and they rotate across Berry's acreage position from east-west to north-south. Down in the lower right hand, there is a diagram showing the relationship of a wellbore, a hypothetical wellbore, and how the completion fractures or the drilling induced fractures would propagate from that wellbore. In the center portion of the map is our subject DSUs in relation to that max stress orientation, and showing that our wells are being drilled perpendicular to that to maximize recovery and prevent waste. Again, the subject DSU is in blue that we're vacating, and the subject DSU that we are establishing is the red box. And I apologize, this map is a little busy and I don't have a pointer for you, but if you have any questions, just please let me know.
Yeah, I have a question. I don't know if we can see it on there. So the red line is a maximum stress orientation data point. I notice kind of right in the middle, there's two red lines. They seem to be vertical, but the maximum stress orientation is not quite vertical. Could you just explain how that interpretation happens?
Yes, sir. So the small red lines are from image logs. So they're an interpreted fracture direction. That part of our field, we don't really have many data points to confirm or deny that rotation and stress in that southern part of the field. And you're correct. We could probably realign some of those lines in the max stress direction in that area. Some of our future drilling programs call for obtaining more of the data to show, confirm, or deny that rotation and stress in that part of the field. Does that answer your question, Mr.
Yeah,
Johnson?
that's great.
Okay.
Thank you.
I have a question, some more. So just on language here, like to me, natural fracture orientation sounds like what's happening under there. Why is it called maximum stress direction? Is there like multiple directions and that's the maximum one?
Yeah, yes, sir. So there's SH min and SH max, and typically, depending on your tectonic setting, those orientations will change. In the Uintah Basin, the uplift of the Uintah Mountains has provided a max stress that is north or east-west in most of it, and it rotates as you get closer to them on the west side. When you hydraulically fracture a well, you're going to open fractures in the path of least resistance, which would actually be in the direction of SH max. So if SH max is this way, you're not going to put against it. It's going to grow perpendicular in that regard.
So is that kind of correct to call it the natural fracture orientation, or is that?
You are absolutely correct. And when we see image logs, you will see partially healed or open fractures in that direction. And then you want to drill your well perpendicular to that.
Okay, but it's more accurate to say maximum stress direction.
Yeah, they're the same thing. Okay. It's tomato or tomato, right? I mean, it means the same thing. It's just what context and how you use it, but it's basically the same thing.
Thank you.
Yes, sir.
Mr. Galecki.
I know you're focused, at depth, but do these stress orientation extend all the way to the surface?
They should. Typically, the data we collect does not go all the way to surface because of costs, and it's kind of out of the realm of what we're looking at. But typically, they do. Yes, sir.
Do we have any other questions before we proceed? Please go ahead.
Thank you very much. And I think this is a good point to add because of the relative simplicity of this request. I just want to make sure that for the record, we're noting that Mr. Boucher, based on what is depicted on Exhibit I in terms of the stress orientation, do you agree that the east-west development or east-west orientation of the subject lands is the proper way to develop these lands?
Yes, sir. Sorry. Yes, sir.
And similarly, you requested 100-foot producing interval setbacks from the east and west or heel toe boundaries of these wells, 330-foot producing interval setbacks from the north and south or the lateral boundaries of these wells, and 100-foot producing interval setbacks between the long laterals and all existing and future other types of wells with up to 16 wells. Do you believe that the geology in this area supports those requests?
I do.
Okay. Do you have
I was going to get back to Mr. Moon's question earlier. To my knowledge, Barry itself has not drilled any 3-mile wells. On the east side of our acreage, we have submitted 5 permits. We've got another several that we're currently teeing up, and we will then march forward with permitting more 3-mile horizontals. So we're in the process of getting those development plans in place.
I have no further questions for Mr. Boucher unless the board or division does.
Board, do we have any final questions for this witness? Mr. Galecki?
Timing wise on production, as you put these out, how long before they'll be, that you'll find out at 3 mile?
Right. I would imagine it's about a 6-month turnaround between starting drilling to getting them on. Yes, sir.
Salt Lake, I should have asked, do you have any questions for this witness? Hearing none, I'm going to assume there are no questions from Salt Lake.
It's just coincidence that all the indicators are C's. That we're not getting. I did actually, Madam Chair, I did have 2 other final questions for Mr. Boucher. First one is, were exhibits G through I prepared by you or under your supervision, direction, and control?
Yes, sir.
And do you believe the relief sought by Barry today will protect correlative rights, minimize disturbance, avoid waste, and maximize resource recovery?
Yes, sir.
Now I have no further questions for this witness.
Sounds good. Let's proceed.
Thank you. I would like to call my third and final witness, Mr. Jacob Wright. Mr. Wright, if you could state your full name, title, and employment, current employment for the record.
Yeah, my name is Jacob Wright. I'm Reservoir Engineering Manager for Barry Petroleum.
And if you could, I've put up Exhibit J, which is your resume. If you could just give a brief description of your education and an experience background in petroleum engineering.
Yes. So my educational background is I have a Bachelor of Science in Petroleum Engineering from Cal State University of Bakersfield with a minor in economics. My work experience has been in California, starting off my career in the San Joaquin Basin with some experience in the LA County Basin as well. The majority of it has been in secondary and thermal enhanced recovery mechanisms for steam flood cyclic injection. I did transition over into a reservoir engineering position or role several years ago. And since then, I've spent the majority of that portion of my career on the subsurface reservoir development side. In terms of operations within unconventionals, I ran the technical team lead position with Barry for our thermal operations within the diatomite reservoir. Operations there are using steam injection to fracture stimulate wells for the purposes of oil recovery. And then some ancillary experience with our operations in our South Bell Ridge field as well. And then within the last 2 years, started working the Uintah Basin, and then heavily as we have began to progress our horizontal operations and development strategies.
And have you testified in any previous matters as a witness, as an expert witness in petroleum engineering?
No, sir.
And so you have not testified before this board as an expert in petroleum engineering?
No, sir.
Notwithstanding our first rodeo here, I believe that Mr. Wright is well qualified to provide testimony today as an expert witness in engineering, petroleum engineering. And so I would submit a request that his testimony be so taken today, subject to voir dire by the board and or division and staff.
Division, do you have any comments?
Yeah, we have some questions for Mr. Wright. You briefly mentioned unconventionals. Could you please give an estimation? How long have you worked in unconventional plays?
Unconventional plays is defined by the industry. It would be about 2 years. What we define, or what my extended experience would be, unconventionals, is we could define them in California, would be our thermal diatomite operations. In that construct and in that reservoir, we are dealing with microdarcy level permeabilities. The only way to extract the oils is through fracture stimulation of the wellbores. In that process, we utilize steam to inject. One, to propagate the fractures. The secondary purpose, though, is we are dealing with heavy oil situations there, anywhere from 12 to 20 API oil. So the energy from the steam is also necessary to mobilize that.
And in the Uintah Basin, how much, as an estimate, how much?
Again, it'd be about 2 years.
About 2 years.
Yeah.
In your current role at Berry, your title is engineer, is that correct?
Reservoir engineering manager. Yes, sir.
Do you have any engineers working under you?
Yes. At this time, I have 6 reservoir engineering working under me, including our Uintah Basin operations.
Okay. All right, no further questions.
Board, do you have questions? Salt Lake, are there any questions?
No, we're good. Thank you.
Good. Any objections to his testimony?
No objections.
He is accepted.
Thank you very much. We'll move into our final sets of exhibits here. And the hope is that, as I noted earlier, some of these exhibits are additional exhibits that have been added pursuant to motion and board order. And we're hopeful that these are going to address some of the division's concerns. But once we get through them, I'll make sure you guys have plenty of time to ask questions and get comfortable. So Exhibit K, this is our setback diagram. This is going to flow directly to our request to establish a 1,920 acre drilling and spacing unit with up to 16 long lateral wells, 100-foot heel-toe setbacks, 330-foot north-south lateral setbacks, and 100-foot inner well producing setbacks. Can you please describe what is depicted on Exhibit K and how this supports the setbacks being requested by Berry today?
Yes. So what, excuse me, what you're seeing on the diagram here, as Mr. Chicken mentioned, is our current well spacing estimate. A single well is represented utilizing that blue line running horizontal, which with the elliptical drainage expectations on a per fracture stimulation basis. From that point, and we'll look at the numbers in the subsequent slides, but effectively with a current setback right now, we are looking at 330, and even with our drainage radius and the extent of that relative to the fracture propagation, we still have a setback of about 63 linear feet from the expected maximum drainage radius lateral, or perpendicular to our laterals. Directly parallel to that, on the minor axis, you see a 12-foot setback with a drainage radius going from the point of focus, which is the blue dot, to the farthest point on that elliptical spacing. And again, the numbers will be represented in the subsequent slides, but that is an 88-foot setback. So this would indicate that we would still be within a 100-foot setback from toe to lease line, with a more than adequate setback looking from the lateral section to the lease line on the parallel path.
And is it your opinion that the requested setbacks are going to increase the recovery of resources, but will still prevent waste and protect correlative rights and protect against drainage?
Yes, it is.
I have no further questions on Exhibit K. I don't know if the board or division would like to ask questions.
Division, do you have questions at this point?
Just based on in here we talk about fracture orientation, estimated 0 degrees, just based on the prior exhibit we saw. There seemed to be a little bit of an angle there. What is that 0 degrees based on? Is what data are you using to get to 0 degrees?
Let me just clarify before he
orientation.
answers. Let me just clarify. I think what you're getting at is this map here.
Sure.
You see some that are not completely vertical, and
Yeah,
but
I would say those. Maybe it's just the diagram.
and that could be it. That could
And
be
that-
it. I'm
that's why I
just
just
trying to
like
make sure that he
I just like
understands.
clarification
He
where the 0
understands the
degrees come from.
question is why do we have fracture orientation estimated at 0 degrees when it looks like here it's not exactly 0. Is that accurate?
Yes.
Okay.
Yes.
Yeah, so and I will leave it to the geology side if there's any additional commentary. My comment would be that the vast majority or the general expectation is that we are going to be effectively at a 0 degree azimuth on these on the stress planes, and as such, this is why we are generating the fracture propagation models as depicted here.
Would geology just take a brief second? Would that be correct? Okay.
Yes, that is correct.
Right. Yeah, with that, no further questions on this.
Board, do you have questions? Salt Lake, do you have any questions?
No questions.
Hearing none, let's proceed.
We will move forward then to our final 2 exhibits here. Exhibit L is, I think, going to get right into what we're talking about here. The Hale and Evers drainage model and how that works into the setbacks that are being requested. Mr. Wright, can you please describe what is being depicted on Exhibit L, and if you can, further answer the earlier question from the division?
Yes. So what you're seeing here is a fracture depth of investigation model utilizing the Hale and Evers correlations. It's an industry standard model for the expected drainage impacts for vertically induced fractures within a horizontal regime. As noted in the initial commentary, that this is the same model and structure that is being utilized for the adjacent orders for the WEM operations. Excuse me. The data that we utilized for these models, both on the geologic side, we can support, but it also is supported by our foreman operations with WEM themselves on a 3-mile lateral basis. What you're seeing effectively is that when running through the estimates and utilizing the geologic data that we have, after 5 years, we expect to be at or below the 100-foot distance in terms of impact from the spacing or from the toe of that lateral. In terms of impacts, if we were to say, what is it going to be, what's the likelihood of impacts farther than the 100-foot offset that we are requesting, we would likely be at roughly a 10-year lifespan or continuous operations for any one horizontal producer before we would start to see potential impacts to offset wellbores.
And similar to my prior question, do you believe that the application of the Hale and Evers drainage model to these lands for this RAA and the 16 long lateral wells you intend to drill in the subject formations, that is, again, supportive of the various heel toe, lateral, and inner well setbacks being requested?
Yes, sir.
I have no further questions for Mr. Wright on Exhibit L.
Division, do you have questions?
Not on this exhibit, no.
Board, do you have any questions at this point, Mr. Moon?
So on the heel toe, you're showing that at 5 year, you're not quite, crossing the line, but after that, there may be some. On the, which I'm fine with, but on the lateral setbacks, you're reaching out a little bit more as time goes on, but you're never gonna even come close to the drilling unit boundary. Is there any thought now of lease line wells, of drilling unit boundary wells in the future?
At this time, there's not. The expectation would be that even if the view is that even if we were to extend to the 10-year view operational window, the subsequent orders for the WEM, just adjacent lands, would push that to as well. At that point, the economic viability of those remaining reserves would have to be reviewed, and we're not at that point yet.
Okay, thank you.
Board, do you have any further questions? Salt Lake, do you have questions?
No
Mr.
questions.
Church? Thank you.
We will move to our final exhibit, which is Exhibit M. This exhibit is, it's entitled Single Well Economics, but it is really a discussion of the additional oil severance and other benefits that will come from the I'll call it the setback reduction from the going rate. It's not, it is a setback reduction that would be equivalent with the associated 130/20 and 130/32 orders lands. So Mr. Wright, if you could please walk us through Exhibit M and what's being depicted there.
Yes. So the first line of this data set is indicating what the expected ultimate recovery on a oil basis would be if we were to utilize a 330-foot offset. The secondary line there is the same metric, but assuming that we would have a 100-foot offset extending out the lateral basis. The expectation based off of, or the expectation in this area is that it's a pretty linearly proportional relationship to recovery of oil recovery to lateral length. And so we scaled there. What that tells us is the belief is that we would pick up an incremental 19,000 barrels of oil over the lifetime of a single well operation. And then the subsequent lines are just simply detailing what the gross projected revenue at a flat $75 commodity price would be. About $1.5 million. Utilizing those values, we expect that by respacing, there would be an incremental $64,000 paid through severance and ad valorem taxes, and additional mineral right royalties would come into the order of about $260,000 to $270,000 on a per well basis.
I know the division's got questions, so let's just say that I have no further questions for you on Exhibit M, and we'll answer their questions first.
Sounds good.
Division.
No questions on this exhibit. We do have questions just whenever he's done with.
Then I will, let me just ask him two quick more questions, and then you guys can have the floor. The first question is, were exhibits J through M prepared by you or under your supervision, direction, and control?
Yes, sir.
And do you believe that based on the testimony and exhibits presented today, that the relief sought by Berry in this cause will protect relative rights, minimize disturbance, avoid waste, and maximize resource recovery?
Yes, sir.
I have no further questions at this time for Mr. Wright.
Thank you. We're going to move into final comments for this issue. Mr. Haynes with the division.
Yeah, before we give a final comment, we do have some questions though from Mr. Wright.
Okay.
His presentation.
Okay.
If that's okay.
Yeah, that's fine.
So Mr. Wright, the request is asking for 100-foot setback, production interval setbacks from existing and future wells. We've seen exhibits that indicate the fracture half length at its minimum is 252 feet. Could you please help explain to the division if the fracture half lengths are that large, why do we need 100-foot intervals possibly between these wells?
So yes, the fracture half lengths, the initial half length expectation is going to be 252 feet. What you will see over time, and again, is represented in this plot, the column that is identified as A sub F, it's the second to column from the right, is the indication of the fracture half length plus some additional length of drainage in that radius. Over time, we do expect that as you continue to drain and draw down the pressure, that you will have some infiltration or migration of fluids from farther out into the wellbore. That does obviously reduce the longer that that well is in operation, just because of the geomechanical properties, permeabilities and such within the reservoir. But you will expect to see that that continues. And so the reason we are still saying that 100-foot offset, we will have some impact or potential impact farther than just the 252-foot half length of that fracture.
So, I mean, just so we understand, because I know the prior orders around here all have a similar request, but traditionally we don't usually see wells that close together. Your development plan, do you expect to bring wells that close together? Like, how do you foresee developing this unit?
Well, what we do see is coming in and developing on a set that would maximize the value of that wellbore. This would be the most aggressive plan, and so the proposal is to come in and demonstrate what the most aggressive plan would be in the event that we would want to or identify that that is the right decision to make. It still gives us some flexibility if we determine that we need to space farther off, that we have that opportunity to, or we have the ability to, but this also gives us the opportunity to space closer together if that is deemed the right decision.
Okay.
Along with that, while they're conversing, is that 100-foot inner well, is that up, down, or sideways, or both?
It's going to be a lot of others.
Okay. Okay.
I do want to clarify, we didn't talk about this because it's kind of, when you have them stacked, there is 100-foot vertical from between those stacks, but this is also asking for a 100-foot lateral between two wells.
Division, do you have more comments?
No, we don't have any additional questions.
Board,
Yeah.
do you have any additional comments?
I'm always curious too why that 100-foot inner well, because we just don't ever see them nearly at all that close. And so just always, but it is kind of the standard thing that's requested.
So
Good question.
I would like to put on the record, and I'm gonna say this, and I'll see if our witness agrees. But my general understanding of the way this works is, in most cases, it's less economic to get that close. But there are circumstances where it might be needed, and rather than having to seek an exception location for that well, they would prefer to have it and not need it, or only need it sparingly, rather than not have it and have to go back. And so I think that's really the key here, is that you know, if we don't trust the math, we can trust the money. And if if you're going to not make as much money getting close together, then obviously no operator is going to do that. But there are times when, and I think we've seen this in other matters, where somebody went out there 8 years ago and just drilled a 1 miler like catty corner right across the 640. That creates weird problems to then come in and put an overlapping 1280 or 1920 and put 16 wells in there. In some cases, you might have to get that close, but that's the point. Is that an accurate representation of the reason for this request?
Yes, sir.
I have no further questions for Mr. Wright.
Division, do you have any additional questions?
No additional questions.
Board?
Just
Mr.
one more
Rowan?
curiosity question. Hale and Evers, 1981. Why are we using a 1981 anything? I mean, there wasn't even horizontal drilling back then. Has that been updated since then, or?
There have been additional updates to reservoir flow modeling, but the premise for most models is going to be based off of first principles that were generated in circa 1980s to 1990s period.
Salt Lake, do you have any questions?
Yes, I have one quick question. I believe earlier we'd heard that Uintah Wax has up to 25% interest in some of these pre-existing wells, and they were notified of this request for agency action, and that would include the 100-foot setback from existing wells. Did they raise any objections to that setback?
I cannot accurately answer on that. I'm not part of that. It might be a better question for our land side.
Go ahead and switch.
Mr. Kopech?
To answer your question, we did not receive a response from Uintah Wax. So the assumption is no concern.
Similarly, I have not received anything on the legal side from Uintah Wax in terms of public comment or response, protest, or concern. So,
thank you.
Thank you, Mr. Questions? Mr. Church, do you have any questions?
No questions, thank you.
I apologize. Just wait, Mr. Kupek's back up. Those 6 wells that Uintah Wax, oh, you said they didn't have it in everything. What are those producing? Like, do you know current production levels of those wells?
I am not 100% certain as to the status. Most of them were producing, if not all.
Okay, thank you. Yeah, but there. All right, thank you.
Exhibit A to the RAA, what I'm showing counsel for the division, shows them all as producing. I think if you want to know, we can probably provide you with production,
Yeah, we can find that. I was just, as that question came up, I just raised that question, and I think since he was here, I'd ask. Okay. But thank you.
Mr. Haynes, have your questions been answered?
Yes, we do have one.
Okay.
The question is for Mr. Wright. Just out of curiosity, in the area, what is the estimated recovery factor for these wells?
The estimated recovery factor that we look at for these wells is somewhere in the range of 6 to 8% overall.
No further questions. Would you like us to give a?
Do you have a recommendation?
Yes. So the division, we've reviewed this request. We've talked about it. We spoke with counsel to get some additional information. The division has, we don't have a problem with creating this unit. We're in support of it. The division, again, just, the 100-foot setbacks, we've expressed concern before. We don't quite understand them, why they need to be that close. In this situation, though, with the ownership, Barry, from our understanding, is the majority owner in the unit. As Uintah Wax, they haven't filed, they haven't opposed. So with that in mind, we look to Barry's business acumen and how they want to develop their own lands, and we won't stand in the way of that. We just express again, though, that's not something we're used to seeing, and if ownership was different, we would be in greater opposition of that. But then with that in mind, we are in support of this request.
Thank you. Board, do we need to deliberate, or are we okay with making a motion?
I'll make a motion. I move that we approve this request for agency action.
Do we have a second? It's been moved and seconded that we accept the proposal. All in favor, please say aye.
Aye.
Aye. Any opposed? Hearing none. The matter is accepted. Mr. Chicken, back to you.
I have nothing further other than to say thank you for squeezing us in today. I know you guys have important other stuff to get to. I will prepare the order.
Thank you. And we need to admit the exhibits.
Oh, we do. I would like to move to admit Berry Corporation's exhibits A through, I believe it's M, but I'm going to double check while I've got the M. Yes, exhibits A through M. Yes.
Good
Yeah,
deal.
no objections.
Board, any objections? The exhibits are admitted.
Thank you very much.
And if you would please prepare the order and
I will,
submit it.
Madam Chair.
And with that, I believe we are ready to adjourn. Before we adjourn, I would like to again thank the Vernal people who've put it together and our production staff over here who has worked hard to make it all come together, and the witnesses here for coming on out. And I hope everyone enjoys the rest of the Energy Summit. It's a great event. Thank you. Do I have a motion to adjourn?
So moved. Yes.
We are adjourned.